You are watching DHTV from California State University, Dominguez Hills.
Hi, I'm Dr. Pamela Kreiser, and welcome back to NCR 525, which is our course on mediation. Last time we were together, we talked about some of the foundations regarding mediation. And now today we have the opportunity to look at mediation a little bit closer. We're going to cover a variety of topics today. The most important one that we'll talk about today are the stages of mediation. And as we go through the stages of mediation, we're going to see that various people will divide the process up differently, but that we will identify that the progression is essentially the same. We're also going to talk about some different activities that are important to do before you go to mediation. We'll talk about some supplies that you need to bring, and we'll also talk about the process of intake, which is an important step before you get to mediation. And then the last part of our content will be to talk about the opening statement. We'll talk about what goes into that statement and some of the component parts and the importance of finding your voice as a mediator. And then at the very end, we have a special guest with us today, Wesley Acker, and he is a mediator who is a good practitioner and an important person to learn from, as he is also a bilingual mediator. So we'll talk about all of those topics today. And so let's begin now with the first topic that we're designed to talk about, which is the idea of the stages of mediation. Now, one of the things to know is that books, mediators, handbooks, manuals, many people identify the stages in terms of the progression similarly, but they divide it up differently. So for example, I follow 5 stages of mediation. However, there are people that identify 4 and some people identify 7. Now, that's kind of an interesting thing to think about because when you think about the idea of mediation, you might think, well, shouldn't it be more prescribed or shouldn't it be more identifiable in terms of the exact stages? And what I would say is actually it doesn't matter. If you think about like a pie and you think about the notion that I could slice it 8 ways or I could slice it 4 ways or I could slice it 12 ways, it's still the pie. And so as you're thinking about mediation, it's important to really think about the progression and making sure the important steps happen, but not worrying so much about the exact stage that you're in, just that you are moving through the stages. And this is something that we'll talk about as we go forward. This first clip is a guy named Edward Nelson, and he's going to use an animated way to talk about the stages of mediation. Let's take a look.
All right, my name's Edward Nelson, and this is the pictorial representation of what a mediator does in a mediation. Okay, the first thing that a mediator does is set the boundaries. Okay, so this is like a petri dish. And in the middle, we have, guess what? An amoeba, okay? The way this works is that we set out the guidelines, the process, we outline the process and the principles of mediation. Within that context, this takes any shape. The content is up to the parties. It takes any shape that they want, okay? Now, after that happens, the next thing that goes on is we give them some space to vent, okay? So this is something that's becoming out of date now, and I was doing some work with kids the other day and they didn't know what it was. And it wasn't just my drawing. It's a pressure cooker, okay? And so the next stage that happens is after we've sent it is they need to vent and they need to let off steam. You know, there's been a fire cooking under here, been a lot of pressure being built up, and we need to facilitate a space for them to let off some steam, okay? Now, while that's happening, this is like a 1950s radar sweeping around. Now, if you know these things, they do beeps, beep, 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 beep. Tracking mining, tracking things that you can't necessarily see or aren't obvious in its sweep around. So every time we hear a beep, we notice that's an issue. We're listening for the issues. What are the things that are really important? And as they talk, you'll hear it come up again, beep, beep, beep. So this is the radar. This is what we do as they're talking, as they're venting, as things are going on, okay? The next thing that happens, we start to choose to focus on these issues. We've got to make a decision about which issue we want to look at, okay? So here we have if you were able to respond to me, you'd be guessing what this was right now. This is where we want to get them to, And this is a big boulder blocking them on their road to wherever it is they're going. We don't know where they're going yet, but right now some of these issues are getting in the way, okay? So we've got one big issue, possibly, and we've got 2, 3, 4 smaller issues on the side. Now what can happen is that we can get caught up in this one big issue, and it might be so big that we can't do anything about it, and it's disheartening. So one approach is to decide to focus on some of the little issues and build up some momentum and show that they can actually work through something. And that happens, they can start tackling the bigger issue. However, it might work the other way around, and usually it does. There's one big issue in the middle, and we tackle that, the rest aren't important. They can sort themselves out. If they work that on out, 1, 2, 3, and 4, they're a piece of cake, they're not even important anymore. So how do we do that once we've gone through? Well, every choice that they make about how they're going to solve that, it's a bit like a little mouse here. Excuse my drawing, but this is a makeshift maze, okay? And we want to get this mouse out of the maze, and we want to get the mouse for the cheese, okay? I know it's a pretty stock standard thing. I could have said peanut butter, apparently they like that as well, but we want to get the mouse through there to what they want, okay? They might be making some choices that are taking them towards, say, the rat trap, okay? The mouse trap, okay? They're going to get caught. Or famously, the mog, the cat, something like that. You want to take them down the route and explore with them which one of them is going to be the best option for them to do to solve those issues. And for each one of those issues, you want to take them out through this process. So here's the mouse here. We're going to guide them. So that's, in a nutshell, the visual, pictorial representation of what happens in mediation. Now, they don't necessarily all happen in that order. You can go cycle around. You might find that you move back up and they've got to do a bit more venting, and you hear a bit more about another issue as they've been working on this. But predominantly, that's the kind of overall theme of the way you want it to go. Okay? That is the stages of mediation.
So as we saw from Edward Nelson, the stages of mediation are important to identify, but one thing you heard him talk about is that sometimes our disputants will propel us back into earlier stages. And one comment that I would make right there is to say that as a mediator who practices mediation and also teaches mediation, I teach about 100 to 150 mediators a year, the thing that I would tell you is that it's not always your engineering as a mediator that can control how you move through the stages. So while I like the idea of moving through the 5 stages that I identify, that doesn't always happen perfectly. And so what I would say is that it's important for you as a mediator to understand the notion that you might have to go back at times, maybe because something was missed, maybe you missed it, but very possibly the disputants maybe didn't realize that it was an issue, or it became more of an issue because of the interaction that you're having. What I would say is very important, a skill as a mediator, is to practice forgiveness. The idea that you would let yourself make mistakes and know that it is an imperfect process, but an important one to know the best practices so that you can be as successful as you can be, knowing that mistakes will be made. And I know that a lot of us come into learning about mediation with the notion that we just are going to try to do it perfectly. And the comment that I would make is that is actually not achievable. So let's talk about the 5 stages that I identify, and I'm not saying they're the only way to look at it, but here's how I see it. The first one is to do the opening statement, and that includes confidentiality. The second one is to identify or work on with the disputant's storytelling and issue identification. Stage 3, building the agenda. Stage 4, negotiating and problem solving. And stage 5, writing and testing the settlement agreement. Now, one thing that I train mediators to think about is this notion of what I call the progress bar. And so as a mediator, one of the challenges that happens is that you have to be present on the interaction level as well as on the progress bar level. Okay, and some of you might call that the meta communication level. They're sort of similar, sort of different. But when we think about the interaction level, those are the messages that you're sending and receiving with your disputants. So when we think about that interaction level, we know that's happening as we go through the mediation. Of course, we're going to talk greatly about the interaction level in mediation. But the other challenge that the mediator has is to monitor the progress. So you know how you go online and you take a survey, and at the very top it shows the progress bar? And it shows you that you're 10% complete or 20%, right? So I think in my mind when I'm mediating, I think about the progress bar. And when I have to make decisions as a mediator, I bounce that decision making off of the progress bar to decide what to do next. And it doesn't mean that I'm rushing through the progress bar, and it doesn't mean that I'm stopping in the progress bar. What it means is that I, as a mediator, have to monitor that level while I'm also interacting. And so that's the same notion. Some of you are familiar with the notion of communication and meta-communication. So communication, the interaction level, where we send and receive messages. And then meta-communication, that level that is like the observation deck for looking at our interaction. And so kind of the same concept, but I really like the notion of the progress bar a little better than just meta-communication as the title for that. Because what it allows us to do as a mediator is to think about, are we moving through the stages? Now, you heard me a few minutes ago say that sometimes it doesn't go in a linear fashion. And some of that is possibly due to you, some to the disputants, maybe to both of you, or all three parties, or however many parties are present. But we can't worry about that. We just have to think, am I helping progress to happen? And then sometimes you'll make decisions that will reflect the notion that the progress bar is stuck. So you might call for a caucus, for example. We'll talk about that in this course. That's where I have an individual meeting with both parties. I might engage in a different practice, and we'll talk about some of those different strategies that are available to move that progress bar. But as we think about the stages, it's not how many exact stages that you have. It's that, are you moving through the mediation, and are you seeing both levels at the same time? That's why, by the way, mediators will tell you that after, and I would tell you this personally, after I do a 2-hour plus mediation, it's sometimes I'm very tired after it because of the intense speaking and listening demands on the interaction level and the analysis required on the progress bar level. And so that's just something to think about in terms of mediating, that you need to be good at both things. And some of us like to be better at one or the other, and you really have to do all those things. And that's why it's a very demanding role. Now, the next example that we're going to watch is an example from Jean Monroe. She's a mediator, and this is a mock mediation, so it's not a real one. But she divides up the stages of mediation into 4 stages. Again, doesn't matter. But you'll see the presence of the same progress occurring in this example that we're going to watch right now. So let's take a look.
Good morning. I want to thank you for being here today and welcome you. Please call me Jean. And what may I call you?
I'm Sally.
Sally, and I know you're attorney. Hello, Paul. Nice to have you back again. And you are?
I'm Harry.
Harry. Good to meet you, Harry. And is it okay if we call you Harry?
It is.
And of course, I know you're attorney as well. Hello, Dan. How are you today? I want to welcome you and make you feel as comfortable as possible. We have water on the table. There's coffee and tea over here on the sideboard if you need it. The restrooms around the hall on the left, so at any time if you need a break, just let me know and we'll certainly accommodate that. And while we're talking about that, does anybody have any special needs? Medication you have to take at a certain time or time restraints?
No.
If there are, let me know because we'll certainly be able to accommodate you. I think you've made a really good choice to come to mediation today. I understand that the two of you have a son, Billy, and I'm sure that Billy is important to each of you. And being able to do this here in a private way, a confidential way, will certainly take a lot of the pressure off of your son. So you've made a wise choice to be in mediation. The courts are docketed, as you know, and you may have to wait months before you get heard. And then the judge is only going to be able to give you a day or a portion of a week to do it. And the things that you'd like to have said, you may not be able to say because of the rules of evidence. But in here, each of you can say everything you need to say, and you can be heard. And I think that's very important because I'm sure with the preparation for the trial, you probably haven't had an opportunity to hear each other. And that's my role. My role is to guide you and help you hear each other and communicate, help you explore all the options possible to work out the remaining issues and come to a resolution that will fit you, Harry, and you, Sally, and most of all, your son, Billy. So again, congratulations for this choice. My credentials are that I'm a Rule 31 mediator, it's approved by the Tennessee Supreme Court. I am a mediation trainer, and I have been a mediator since 1992. I'm also a lawyer, but I will not be wearing my lawyer hat today. You have very fine counsel to do that for you today. And at any time that your lawyer needs to talk to you or you need to talk to your lawyer, feel free to let me know and we'll arrange that. By the same token, if you would like to talk to me alone in a private session, we can arrange that, and whatever you tell me there will also be confidential. There are several rules that make this work better. As I mentioned, it's confidential. So nothing that is said in here can be used against you in court, nor can anyone subpoena me to go to court to testify. Let me ask you if the two of you as well would like to keep this confidential.
Yes.
Yes, very good. So we already have our first agreement. The second rule is that we would ask for your full honesty and disclosure of anything that might help us resolve this case, and you'll agree to that as well.
Certainly.
All right, thank you. The third agreement is voluntary. We may be here under a court order, but the decisions that you make will be your own. No one can coerce you, neither your attorney nor I nor anyone else. It's going to be your voluntary decision. So the two of you will be the decision makers. But if at any time you feel that you would like to leave this process, that is your choice. You may do so. I would just ask you a favor. Will you agree to stop and speak with me in a private session first to see if there's some way we can put this back together? Because I think you'd be leaving a very valuable process. Would you agree to do that?
Sure.
And would you? All right. And then the last one is mutual respect. We've already agreed to talk to each other about using first names. I would like to ask that you speak only from your own perspective, rather than tell me what Harry thinks or what he's up to. Just tell me what's important to you, what you need. And rather than tell me what her motivation is, tell me what you'd like to see happen in the future. I also ask you to be open-ended and flexible, open-minded and flexible. Your attorneys are going to have a little different role today than they have in court. I'm sure you hire them because they're aggressive attorneys who will do a good job for you in court. But this is not an adversarial process. So we're going to ask them to do something that lawyers aren't very good at, and that's be quiet. And if any time, though, that you need to talk with them, you may do so. But the two of you are going to be doing the talking today. So is everybody good on that?
Sure.
All right, let's go. Let me explain a little bit about the 4 steps. We're almost through the introductory step, the introduction. The second piece, I'll be hearing from each of you about what's important to you today, what your goals and concerns are, and what you'd like to achieve at the end of the day. Then we will throw up as many options as we can think of on this chart, and maybe ones that you haven't even thought of before. And there are no bad ones. We'll put the good ones, the bad ones, whatever. And out of that, we'll find ones that will work for you, and we'll write them up, and that'll be the 4th step. And you'll have an agreement that your attorneys can review, you can sign off on, and you'll be done. It'll be over. So are you good to go?
Yes.
And how about you? Well, if that's so, let's pass this agreement to mediate around. And where are we going? So Harry, you are concerned about whether or not Sally can afford the house. Can you tell me a little bit more about that?
Well, sure. I've always been the one that earned the income. She works, but her income doesn't justify a home like we live in. And her comment that she'd like to keep the home and have a suitable home for Billy really is impractical. She knows she can't make enough, even with the child support, to sustain that house without having to go get another job or something. And if she does that, who watches Billy?
I do agree that it would be very hard, and that I would need a higher paying job. I hope that I might be a little more qualified than
Harry gives you credit for.
Yes.
We have a lot of equity in that house, but it still has a substantial mortgage on it, and the payments have to be made. And I don't want to lose that house because she gets it in the divorce settlement and then can't afford the mortgage payments, and she gets behind, and who's going to save the house? She'll come running to me.
So one of your solutions is either to get a better job or a second job. Do you have any ideas for making this economically feasible?
Other than selling the house, you mean?
Okay, so selling the house would be your choice, selling the house and dividing the equity.
And then we could both have a nice home.
So option 5 would be to delay for a period of time, paying him his portion.
I know that would seem hard.
So what could you do with this proposal that might make it more palatable to him? Can you think of something that might make him willing to delay? Put our heads together and see if we can think outside the box and come up with some kind of an answer. I wonder, Billy is 13, I understand, so he has 5 more years of minority. Anything to do with that?
Well, the desire that we're talking about is that Billy would have a nice home with her and a nice home with me. And
Well, congratulations, Harry and Sally. We've reached a complete agreement on all of the issues, and it seems like an agreement that you both can live with and feel good about. And let's review it, and I have written it out here that you can follow on the flip chart that we've done. You've already agreed on the co-parenting time and the child support before you came. Today, we've agreed that each of you will pay half of the mortgage for the next 8 months to give Sally time to get into this new job that she believes that she'll have. She will attempt to refinance the house within that 8 months, but if she's unable to do so, she's agreed to sell the house and attempt to find another house in the same school district so she can accomplish it. So is that the totality of your agreement?
that sounds right.
And you're both willing to be bound by it?
Yes.
All right, I have written that out here, and I will pass it around for everybody to sign, and we'll be done. And then your attorneys will take this memorandum of understanding and put it in legalese and present it to the court for the court signature, and everything will be finished. So again, congratulations.
Well, thank you. I appreciate what you did today.
You're welcome. Thank you, Dan.
Thanks, Jim.
And thank you, Paul.
Now you notice in that clip that she combines stages 2 and 3, but it doesn't mean she doesn't accomplish what are in those stages. It just means that that's how she slices up the pie. It just gives you a further example of the notion of how we might move through the stages, that all those things need to happen. It's just about understanding your conception of the stages and how you slice it up and making sure that you have that progress bar in mind the whole time when you're mediating. Now, let's talk about delivery of the opening statement. Of course, one of the main things to think about is eye contact. You saw that example is a pretty good one in terms of eye contact. She seems pretty comfortable with her own style. And you want to think about a lot of aspects of the opening statement because that's where you're going to start to build the rapport. And we're going to talk a little bit more about that in a few minutes. But the idea is that you have good eye contact. Of course, you need to make sure you hit all of the main points in that opening statement. So that's kind of interesting. And then also to think about the nonverbals that you have. And I would actually suggest to you that you think very strongly about the notion of congruence. So what do I mean? I mean that your verbals and your nonverbals, so the things you say and how you act, are congruent. And that's just going to be my personal training in interpersonal communication to suggest to you that is very crucial for you as a mediator to practice your delivery in terms of all of the aspects of mediation and to strongly consider the speed, the eye contact, the posture, the word selection, all of those things, and making sure that your verbal and your nonverbal are congruently working together. Now, one thing we talked about earlier that is time to talk about now is this idea of bringing the appropriate supplies to mediation. And I know that seems kind of funny because sometimes we are able to control the settings that we mediate in, and sometimes we can't control those settings. So I have been working at courthouses before where there is a designated room for mediation, and then I've also seen courthouses that doesn't have a designated room. You might be mediating in the hallway. So when you can control the supplies that go into the room, I would suggest that you think through those supplies before you get into mediation. And so what are the supplies we're talking about? We're talking about a calculator. We're talking about tissues, perhaps water, of course, the necessary forms. You might think about any other information that's needed for the disputants, like the confidentiality agreement, those forms that we talked about a moment ago. The other one that I would talk about too is this idea of having either a watch or a clock. And the issue is that many of us rely on our phones at this point to tell time. And the problem with that I've found is that if I use my phone, then my disputants tend to feel that they can use their phones. And so one of my ground rules in my opening statement is that we can't use phones unless there contains some evidence that we deem important to the case and would decide to selectively use for evidence. So what am I saying? That mostly we don't use the phones. And I suggest that they put them away and that we don't have them be out during any time during the process. So because of that, I need to have a watch or a clock because I can't monitor the time frame. And sometimes that's important in terms of getting back to when the court session is expiring. And so you might want to get your mediated agreement in by a certain time before lunch happens or before the end of the day. And so I also think it's good to monitor for the breaks that you might need in mediation. If you have no concept of time, that's going to be very hard for you as a mediator. So think about a watch. And the other one that I mentioned first was a calculator. And I want to tell you a story about something that happened actually in a mediation I did, I don't know, maybe a year ago. It was a landlord-tenant dispute. It was in small claims. And both of them handed me their Excel spreadsheets. And initially, I looked at those Excel spreadsheets, and they didn't look right to me. I don't know why I thought that. They just didn't look right to me. So I had a calculator, and I decided to add up the columns just to see if the numbers were correct. And what I found was that both of the Excel spreadsheets had errors on them and didn't add up. So we had a suit amount, and then we had two other numbers that were present on the Excel spreadsheets that didn't add up, and they didn't match the suit amount. So now we have three different values. That was important for me to see that as a mediator because we had to go back and actually talk about those numbers first before we could even really get into the issues between the landlord and the tenant. So what they had done is used Excel to actually put their numbers in, but they didn't use the actual function to add up those numbers. So when I did that on the calculator, that's where I got the actual difference in the dollar amounts. So that's kind of just a story from my own mediation experiences to tell you that I usually add up everyone's numbers also with that calculator because of that piece of history that I have in my own mediation. Just the notion that it's important for us to make sure we know what we're all talking about. So in summary on the supplies, just think about what you need and think about what might happen. I know that some people say, oh, you need more tissues in civil harassment than you do in small claims. And what I would say is you need them everywhere because we're emotional people who sometimes think. And what does that mean? That emotions really can be present in any kind of mediation, even one that seems like it shouldn't be emotional. And so what I would say is you just want to have a good set of supplies so that you can set yourself up for success. Because at the end of the day, that's what you're doing as a mediator. You're trying to help these disputants get to a better place than when they arrived. So what does that mean? That means that I am trying to help them. That's it. And so whatever supplies I need to do that job better, that's what's going to be on my list. Now, let's get more specific now about this idea of intake. And I would start that conversation by talking about the notion that you might mediate in a neighborhood justice center, you might mediate at your workplace, you might mediate in the court system, You might mediate in a law office. It's hard to say where you're going to be mediating. But one of the things that we like to do when possible is to do this process called intake. And intake often happens over the telephone. So if I get a referral, I might call the person who is requesting mediation, and that would be the claimant. And I would actually talk with this person about the features of the case. And so I want to talk about what that conversation would go like, and also acknowledge that I would have 2 separate phone calls if I had 2 parties, where I might be doing intake. And what am I doing? I'm gathering as much information as I can about the case to try to serve those parties better. And then the other thing I'm going to do is educate and sell mediation. So those are a couple different ideas as we talk about this notion of intake. So let's talk first about the demographics. Now we do intake, by the way, in court. We do a little bit of intake where I serve, but also we do it in the agencies for sure. And some of that is to qualify parts of the service that we're providing, and some of it is to actually track it, to prove that we're serving people like in terms of a broader scale of demographics to the organization. But what I would say about intake is that my policy is we try to get as much information as we can, but we don't want to worry about if there are parts that we can't get or aren't suitable. So sometimes, for example, people don't like to tell me their income level. And for my purposes, I'm going to ask them for that in terms of what I plan to do as a mediator, but I might have to explain to them that the reason I'm asking for the income level is to see if they qualify for free mediation services. And that really, again, goes back to context. Are you serving in an agency that provides free mediation versus is there a fee structure where you might be providing mediation services for a particular amount of money? And that is going to depend on the context. So lots of different avenues for mediation, but initially you're going to get the demographic information, and usually the complainant is the person who filed. Sometimes we call that person the plaintiff in small claims. Sometimes we call it the petitioner in civil harassment. All the same name, the person who filed. And so I usually start with that person, and then I also ask them in that process, have they mentioned mediation or mentioned that I might be contacting the other party? And so we have a whole conversation about the demographics, and then we get into the idea of seeing if the mediation is suitable or if the case is suitable for mediation. So sometimes individuals will come to me and ask for mediation, and I will, for a variety of reasons, determine that the case is not suitable for perhaps my agency or my skills or for other reasons, maybe a conflict of interest or different elements. So what I would say about that is that you have to decide how you want to have your progression go in that phone call, but you need to talk with those disputants, both of them, in the 2 separate phone calls, about is this case suitable for mediation? Does it make sense to do that process? So the other thing that we would talk about is this idea of convening, and 2 really key words there to talk about. The idea is that we're selling mediation and we are educating about it. Now, one of the things that I'd tell you is that from my experience, if I ask anyone what mediation is in a courthouse, almost everybody says, if I say, do you know what mediation is? They say, oh yes, I know what it is. And then frequently we get into mediation and they say, what's mediation again? And so I'll be ready to explain that. I think people think that word is something that they should know, or they believe they sort of understand because they know what a mediation kind of idea is. But I wouldn't say that I largely come across people that have ever been in mediation. I would say a very large majority have never been to mediation. And the other comment that I would make is that most people say they understand it, but they don't actually know any of the details about it. It's okay. What do we do when we find out that they don't understand mediation? We explain the process. And the most important part that you heard even in the first show, and I'm going to say this in every show, is the notion that the disputants control the outcomes. And that's going to make it very, very different from any other form of ADR, because that is the hallmark, that is the distinction of mediation. So I'm going to educate them on what mediation is, and then I'm going to sell it as an option. And you can sell that a variety of ways. So one thing that happens in court is that in small claims, for example, we'll be talking with the possible parties that might be considering mediation, and we usually do this in the hallway. And as we're talking with them, they say, hey, what are the benefits for me? And for the plaintiff, that might be more details regarding like the payment structure, if they were to win that claim. It might be some of the payment options or some of the deadlines are more specific in a mediated agreement, so that would be a distinct advantage for the plaintiff. And for the defendant, of course, it doesn't show up on their credit because mediation is a separate process where we mediate it, and so then that mediated agreement is the judgment and therefore not against their against them. And so when we think about those processes, that is actually a selling point for both of them and a reason to do mediation, perhaps. Now, that doesn't mean that I'm trying to talk them into mediation that isn't appropriate. So there's sort of a fine line there to think about, is to say, when you're thinking about yourself as a seller of the mediation idea, what you want to do is to simply paint the alternatives for the disputants. And in doing that, then you kind of sell the idea that they have control. And if it's a suitable case, which you've already talked about in that intake phone call, then you can identify it as a way to go forward and as a strength. And so just think about that as part of your intake process. So we've talked about doing the demographics and making sure you have all that information. Usually, by the way, when I ask for the phone number, I identify which number is the best number to call. And I also distinguish whether texting or emailing is preferable in terms of setting up the scheduling. So be aware of that. But then also be aware that sometimes intake never happens, because sometimes I'll have cases where I know absolutely nothing about it. And I have just been assigned the case, and 1 minute later I'm doing the case. And so then in that case, I don't have any kind of pre-information. I maybe don't even have their names, or maybe I just have their names. And so that for me is a different activity. And so, but you still have the same kind of ideas where you do the demographics if you have an agency that needs to collect those. You just do it then. And then you also have the notion that you need to explain educate what mediation is, and then also get some buy-in on the process with the notion that they control the outcomes. So the buy-in is just buying into the notion that this format would be used. And so that's how we think about it. So we've talked about the 5 stages of mediation. We've talked about that first stage of mediation being the opening. And when we talk about the opening, we're talking about the opening statement that includes also the confidentiality. So both of those processes are occurring. And we want to take a closer look at that opening statement now and really talk about some of the functions as well as some of the component parts. Now, the first thing I'll tell you about opening statements is they vary greatly depending on the mediation. I know it makes sense that you say, wait, I have a set opening statement. This is the opening statement that I give. But I would tell you that that isn't actually how it happens in actual mediation. It really depends on the context. So the dilemma of the opening statement is that it's not so short that your disputants are not able to do the work of the mediation, but it's not so long that they become bored by it. And that is just a really interesting challenge. And the comment that I would make also is that your delivery will greatly impact that. So if you have a longer opening statement, but you have great delivery, you're going to get away with that more than if you have poor delivery. So you're going to want to really think about that delivery and how important that is to the process, with the notion that that's going to really extend or diminish the capacity of attention for the disputants. The example that I like to give is, I've taught, this is the end of my 30th year of teaching at the university level, and so when I first started, I had, a 2-page syllabus, and then over the years, we have all these legal things that happen or different policies, and, we keep making those syllabi longer and longer. And we always joke that we need like a phone book of a syllabus. We need like a very long catalog of a syllabus to explain all the things that everybody needs to know. But I don't want to do that because I know people won't read it. So I've got to put in enough in my syllabus that are like the most important parts that need to be put in writing. But there are other things that I don't put in writing that are also important rules maybe at the university that I will just bring up if they're needed. Okay, so here's an example, like in my in-person classes, my live classes, Everyone knows not to bring a giraffe to class. It's a rule, right? You can't bring animals. So the thing to know about that, and there's also rules about service dogs and those kinds of things, right? But I don't put that in my syllabus because it's a rule, but it maybe isn't a rule that will come up. And so part of the dilemma is figuring out which rules are likely to come up or likely to be important to the mediation and making sure those are included in that opening statement, but not worrying if there are other elements that you need to kind of remind the disputants about that could be important. Like, I don't say there's no smoking in the mediation, but I would bring that up as a rule if it became a factor in a mediation. I've never had anyone smoke in a mediation before, but we might say, gosh, I could include that. I could make my opening statement 40 minutes long. And the problem with that is I sacrifice the attention of the disputants. So what are you trying to do? You're trying to make it include all the important parts and make it be efficient and well delivered so you set them up for success. Let's take a look at the different parts to talk about that should be or are likely included in an opening statement. So the first one is a welcome, and we welcome people into the session. We introduce the parties and identify how we're going to address each other. We might make a statement of credibility, maybe about your experience or about your training. We want to verify the stakeholders and their decision-making ability. So who's involved? Are the right people in the room? Explain the nature and the scope of mediation. So this talks about the disputant's self-determination and volunteerism. It's a voluntary process that they engineer the outcomes. We might even explain a brief overview of mediation. We explain the mediator's role, so establish boundaries, talk about how there is no judgment made on the part of the mediator, and the decision-making is left entirely to the disputants. We might explain the caucus, which is a private meeting with each of the parties. We might talk about impartiality and neutrality, so the mediator has no stake in the outcome, no bias, is dedicated to fairness and equal treatment of the disputing parties. We would talk about confidentiality and identify expectations. Would most opening statements talk or refer to note-taking and mention that the documents associated with the mediation will be destroyed after the mediation? Establishing the ground rules. This is something that I do in mediation, where we have one person speaking at a time without interruption. We don't have personal attacks, no swearing. Maybe I might talk about the expectation of civility and courtesy and getting all parties to agree to these rules. Another component that might be in your opening statement is to address time constraints, how long you believe that session is likely to go on, and what expectations might be set regarding that. You might also discuss the possibility of outside experts. In other words, whether attorneys are a part of the process or not, or whether they can be consulted and how that process would occur. Talk about whether the disputants are committed to the process of mediation. You saw that in the example that we showed with Jean Monroe. And then transition out of that opening statement into storytelling, and you'll have to make some decisions about how you want to do that. So one of the concepts that I want you to think about very seriously is finding your own voice as a mediator. And I know that seems kind of like a funny statement to make, but one of the most important parts of my education of mediators that I do yearly, and you heard I train a lot of people in mediation every year, is that I don't want to replicate myself. I'm not trying to make 100 versions of me out there, 150 versions of me. What I'm trying to do is to help mediators find their own voices, and you'll find that your style and your abilities and your strengths will be part of your voice. And so part of that is just seeing what is your best practices, or what are your best practices, and how do they interface with what is uniquely part of you as a mediator? Because all of us have something to offer, and it's just about finding your own voice as a mediator. So let's take a look at this first example of an opening statement, and I'm going to give you a few of these, but let's watch this first one, and then we'll talk about it.
Morning, Katie, Andy. It's nice of you to be here. I'm Mark. I'm your mediator. I know that you have been asked by NBC to come to this mediation, and I appreciate the fact that you're here. You should know that mediation is both voluntary and confidential. That basically means that even though your company has encouraged you to be here, if this doesn't work for you, you can, either one of you, leave at any time, and there is no penalty involved in that. It will simply be a mediation in which it didn't work out at that point in time. Now, by voluntary, I mean that I'm going to treat your participation as somebody who wants to be here and is looking for a solution. By confidential, I mean that anything we say here stays here. The only thing that can leave this room by law is any written agreement that you may reach. And I say may because you're under no compulsion to reach an agreement while we're in mediation. My role is to help the two of you talk. I don't make decisions. I don't tell you what to do. I am here as a facilitator of your discussion. I'm a neutral. I've been hired by NBC for this process. I don't work for them. I have no allegiance one way or the other to them other than helping you guys do this process.
Now, the next clip we're going to watch is a different mediator, and you'll see a different style. Here's Thomas Meyer, who's mediating his opening statement.
Hello, my name is Tom Meyer, and I'll be your mediator here today. If this is your first time mediating, let me say it's very normal to come into the room with doubt, skepticism, and perhaps a very, very low expectation as to what might be accomplished when you consider that I am not a judge and that I will not be making any rulings or determinations about who's obligated to pay or recover anything as a result of what we discuss here today. Most people would rather simply avoid mediation and continue to pursue their case and get to trial. However, most people are also engaging in that strategy without knowledge of the facts. And the most important fact that most people are not aware of is that the overwhelming majority of lawsuits, meaning over 90% of the lawsuits filed throughout the United States, never get to trial and end up out of court. It's just a fact that somewhere along the way, most litigants find a better way to resolve their dispute and have to take it out of court. It's my job today to see if we could come up with a better resolution for you to also take your dispute out of court.
Now, as we looked at both of those opening statements, and then we saw the one previously by Jean Monroe, you're seeing lots of variation in terms of the style and in terms of the delivery of the opening statements. And the comment that I would make is that you need to think about practicing and you need to find your own voice so that you can deliver the best opening statement possible. But know that there isn't a correct way to do the opening statement. What I would suggest the terminology we use for it is to say there are more productive ways to do the opening statement and less productive ways. And so as you're evaluating your effectiveness, that's how I would say to think about it. We wouldn't say an opening statement is good or bad. We would just say, is it more effective or less effective, or more productive, less productive, and is there a way for us to make it more productive? When I think about mediation, you've heard me talk about this already, I'm thinking about my disputants entirely. What is the best job I can do for them to get them to a better place? It's not about me. And so as I try to have good delivery, the comment that I would make is on some level you want invisible delivery. And that is an interesting concept to think about. When I talk about invisible delivery, I mean that the delivery is so good that you don't notice it. In other words, the disputants in my mediations, the best job I can do any given day is to not have unusual nonverbals or strange words or poor eye contact. Any reason to call attention to my delivery might distract them from the words that I'm saying and the process that we're achieving. And so what I would suggest is that this notion of invisible delivery is what we're after. The idea that our delivery doesn't interrupt any part of the process. Now, as we think about the opening, I want us to think just briefly about some of the goals. What do you want as the outcomes that are related to the opening statement? Of course, you need to get the confidentiality agreement signed, so that's very crucial, and you need to set the ground rules. But some other things that need to happen in that process is you need to build rapport. And so as you're building rapport with your disputants, you have to have some delivery that matches that intent to build rapport. And so think very strongly about the idea that your delivery will impact that. Of course, you want them to trust you. And so something that I talk with beginning mediators about quite a bit is this notion that you and I have to select words that make the most sense so that we can be trustworthy. We use our phrasing carefully. We sound neutral. We phrase things without evaluative terms. You heard me talk about this the last session. Just be very cautious about inserting words that are unnecessary because you want to maintain that professional, fair, neutral third-party facilitator or demeanor and try to get them to a place of success, which really doesn't have to do with you. So in that invisible notion, you can kind of see my philosophy show up there a little bit. Let's see, what else can we do? The other thing I think is a good outcome of a positive or more productive opening statement is the buy-in. And I know they sign the confidentiality and they say, I agree to the process. But the other comment that I would make is, you really want, on some level, the physical buy-in, the signing of the paper, but you also want the emotional buy-in. Have you established enough trust and enough professionalism, enough rapport to get this mediation off the ground? And so as you're thinking about writing your opening statement and as you're drafting it, I would, by the way, suggest you type it, not write it out, your first draft, because you're going to edit it all the time and it will be a working document. You might even have multiple versions of it. And so just be aware of that, but get comfortable with that. Find your own voice and focus on what you are achieving for the other party. So it's tempting for us to get worried about me and worried about how I sound and how I look and all those things. And what I would say is once you get that opening statement down, it's really about them. And that's where you need to focus. All right, so the last part of our show, I have a guest who is coming on. And this is Wesley Acker. You might have seen him before in my other class, NCR 507. Wesley is a mediator in Orange County. And in a few minutes, we'll be back to talk with him about his experiences as a mediator.
You are watching DHTV from California State University, Dominguez Hills.
Welcome back. Today we have a special guest, Wesley Acker, who is a mediator in Orange County. Welcome back to the show.
Thank you. Good to be here.
Glad to have you. We have lots to talk about today regarding mediation. And so I appreciate your willingness to battle the traffic and come to the studio today.
Yes, it was quite a battle. But
It's always a battle out there.
it's good that now that I'm here.
Yeah, so I guess that tests the patience of the driver, and maybe that's something that is important for mediation too. I've been thinking about patience quite a bit.
It's difficult to mediate a traffic jam.
Yeah, you can't. No one controls the
listening
outcomes.
to you, that's right.
Yeah. So I want to start, and this is something I've known you for a while now. I don't know your background, how you became a mediator. Tell us about that.
Well, I was teaching at university at Old Dominion in Virginia, and I happened to be working with someone that I hadn't worked with before, and noticed on the end of her email that she was a mediator and a trainer in mediation. And I was curious. It always sounded like something interesting. So I found out she was part of a large nonprofit, and within about a month, I started training to be a civil level mediator, and then I eventually went on to get my family certification as well. All in about 9 months. It was kind of a quick journey.
Yeah, and family is a whole nother.
It is.
We'll talk about that in a few minutes.
Yeah.
So you were in Virginia. You did that training. Then did mediation for profit, for nonprofit entirely?
I donated my time to the nonprofit there, and I did that quite often. Actually, I do probably 2 to 3 a week at times. It's nice being a professor. At the time, I had some leisure,
Yeah.
free time to be used elsewhere.
I don't know that we always have leisure
Not always.
time. I'm scared about that comparison,
Right.
but yeah, okay. So you were a mediator in Virginia, then you relocated at some point to California. I don't know if that was a straight line or not.
It was.
Okay, so when you relocated here, tell me, one question I get all the time is what do you do if you've been educated out of state? How do you transfer that? Like, how does that work? So how did that work for you?
Yeah, something that's positive about how mediation is handled in Virginia, it is regulated by the state. So you become certified within the state to mediate anywhere. And there isn't technically a certification here
Right.
managed by the state or handled. So that's always challenging because the first thing you want to do is be able to present your credentials. It's easy to get one from Virginia. If you're getting yours here in California, you're going to have to make sure the other state is able to receive your certificate here.
Okay, so then so the state of Virginia provided evidence to, well, you don't
Yeah.
really have to provide it here, or you,
Here, well,
to
and
certify your DERPA?
right. So under the DERPA agreement, I worked with a nonprofit, OC Human Relations, and they were okay with all of my materials. They saw my certificates and the number of hours I'd put in to certify.
Right, okay, and then your family mediation training, was that in Virginia, or was that?
That was also Virginia.
In Virginia, okay. And then what kind of cases did you do in that role?
It would be divorce, separation, things like adjusting child custody, determining, well, it was a unique situation because it's a Navy town. So there's a lot of deployment, and divorce happens at strange times and in short measure. And so we dealt with some interesting cases.
Oh, that's interesting.
Yeah.
Okay, and then, so you were able to transfer both certifications. I guess you
Correct.
had them as certifications in Virginia.
Correct.
You're able to transfer both. Now, I guess from your story, it didn't sound like you always wanted to become a mediator, or did you?
No, not at all. I actually taught at university at teaching dance, believe it or not. So the interesting thing was, once I understood what mediation was, I realized teaching people to dance is almost the same thing. You're helping them have a conversation. And that's literally what a mediation is. They don't know how to work together. And two people trying to dance is kind of challenging when they're first beginning. And guess what? They need to have a dance of their languages. They have to be able to work with each other.
And one of the thoughts that occurs to me as you're explaining that is how skill-based both of them are.
Absolutely.
So I get the question all the time, and I'll ask you this question too. The question I get is, can everyone become a mediator?
Good question. I think probably the most important thing you need to have is the willingness to stay with the process and to be patient.
Just like when you're driving on the 405.
Just like that.
So maybe that's the training ground for the
It
patience
really
that
is.
has to happen.
Yeah.
Okay. So one other question that I get quite a lot is, can someone make mediation a career?
Absolutely. Especially nowadays, there are types of mediation here in California, for instance, that the courts mandate that you go through a mediation process. So you could work for the county, let's say, in that type of role. You can work for nonprofits. You can have a private practice. There's actually some pretty high-level dispute resolution specialists that would also be considered evaluative mediators, and that means they not only are going to get the parties together, but they're also going to kind of advise them, and it's a little more like an arbitration. In other words, you can find a career at some level if this looks like it's something you want to do.
If you're an evaluative mediator, do you need to be a lawyer?
Depends on the type of mediation you're doing.
Okay.
The reason is evaluative simply means that the mediator is going to offer some type of expertise. They're going to evaluate the case on both sides and then give advice.
Okay.
Even if they don't make the final decision, their job is to help nudge based on their experience.
Okay. So, and I have talked about context with my students and also on the show. It does seem that context is sort of everything.
Kind of so, yeah.
Because you have the different judges, you have the different systems, you have the different types of cases,
Right.
different expectations. You and I have served some of the same people in
Right.
court, and some of them, as I've talked about in a previous show, will say, I order you to try mediation, which is a voluntary activity, right? And
Right.
so we've been, I think, in that same courtroom doing that, and that's always an interesting moment where they think, is this voluntary or is this not voluntary? And then there's also, like you're describing, those types of cases where it's not a choice. You're going to
Right.
try it first.
Right.
Which is interesting. And people debate that quite a bit, like whether that's a good thing or not. And I would say it depends.
Yeah.
Because you don't want to railroad people, but then you also, there's so many people that think they know what mediation is and then they don't really know what it is.
Right. And I think it's appropriate that officer of the court, a judge, someone like that, can mandate them to try it. In Virginia, everybody that goes through a divorce is already sent to mediation. They have to give it a try. If they refuse to settle, that's up to them. But they don't go before a judge without seeing a mediator first.
Okay. All right, so let's switch gears a little bit. I
Okay.
want to ask you about your philosophy.
Okay.
Do you have a philosophy of mediation?
Yes. You need to make sure that everybody is understanding it's in their interest to find a best solution for them, rather than feel like I need to win. So as a mediator, my job is to, number one, keep putting things out there that helps them understand what's in your interest, what's going to actually help you. These are when people make a decision they're able to stick with, and they actually might recommend mediation to someone else.
So how does that philosophy show up, like in your interaction per se? Like you talked about putting things out there. I sort of think that all of us have a philosophy, whether we know it or not, and it shows up in our interactions, whether we like it or not.
I agree.
So how would you say that shows up, like in your actual, on the interaction level?
Well, a lot of times what I'm doing is, as I listen to their story, their case, so forth, I'm looking for those interests pretty quickly. And then as I restate, I might bring out how that opens things up for them if they take a look at what's in their interest. I won't say, it's really in your interest to do this. That's not my job to advise.
Okay.
But as I'm giving the information they gave me, in a restate we call that, I'll add, and it sounds like this, and they'll start saying, and that's true, isn't it?
So you like highlight their own idea for their own discovery in a way? It's
Right.
like helping them discover it as
Right.
an issue or as a component?
Right.
Okay.
Not adding new information.
Right.
Simply pointing out something that's already in their interest.
And you and I have talked at great length about neutrality.
Right.
So that obviously goes to that notion, I assume, or hear that that's part of your philosophy, is to really stay neutral.
Absolutely. And we talked about that it's voluntary. I'm solid on that. I really feel like if a person feels under duress or being coerced somehow, then we need to stop the mediation until things can become more balanced. People make poor decisions when they're under that feeling.
Yes, okay. So let's talk about family and divorce mediation. It's something that I don't specialize in. I know about it, but not personally because I don't mediate in that court. What are some things you could tell us, for people like me who don't do that mediation, what are some things that are unique about it? What are some challenges that you face? What's your experience like in there?
So a quick comparison to, let's say, civil cases or small claims. Those have a limited amount of relationship between the parties most times, and it's about money. Whereas the money may be a big factor in a divorce case, of course, but the relationships have been ongoing, and there's been potentially a lot of harm done one to the other. And you are not really there to heal or rectify those harms. And that's challenging.
Yeah.
It can happen in a mediation where they're both really willing to participate. It can happen. But it's not your responsibility. What you're asked to do is help them dissolve the relationship in a peaceful and hopefully most beneficial to the parties, including kids, which is always a big factor. So you're hoping for them to come up with the best solutions that they can live with every day. And whereas in a civil case, you're hoping it's done. They want to know, I want to go away from this when it's over.
Right.
This is an ongoing thing. They have to be willing to stick with that agreement for a good while, at least until the kids are 18.
Right.
Yeah.
So that's a tricky part of that I hear you saying. We're dissolving the relationship that's going to be ongoing. So it's
Right.
sort of like dissolving the past.
Yeah, well, it's dissolving. That's a nice way to put it. It's the marriage relationship is dissolved, but they'll be related
Yeah.
forever
Yeah.
through the children. So yeah, it's a new relationship that you're kind of creating, and they don't necessarily even want that one.
Yeah.
Yeah, they're hoping that it was over, but what really it is taking a new shape.
Okay, so we could even almost say that you're the dividing line into the new,
Right.
here's what we're doing to dissolve the past,
Right.
and here's how we're going to agree to approach the future.
That's right. And
Yeah.
we actually talk a lot about what is in the past. We like to allow it to be there and say, what does your future look like? How do you want things to move forward?
So let's talk about the length of those mediations, because I'm used to, I do small claims, I do civil harassment. Small claims frequently is like an hour-ish,
Yeah.
right? And then civil is like 2 hours-ish, because it has all the
Relationships, right.
issues. So how much does this time frame expand in the family court?
So if here in Orange County, if we were doing a case that's given to us, there's usually only a couple topics that the judge is asking them to see a mediator for. So you will likely be about an hour and a half, and then that area we'll write the stipulation up for those things, send it
Okay.
back to court. However, if you were doing an entire divorce, it's typically 6 hours, maybe a little more, depending
Yeah.
on what level of dissolution is required. If there's businesses involved and lots of properties and so
Yeah.
forth, and pensions, and so all these things need to be broken down and understood, and then make the steps forward. So yeah, I've had one go over 12 hours.
Yeah, I can't imagine. I mean, I think it would have to maybe be that long.
And it's usually 2-hour sessions because
Okay.
everybody gets a little tired.
Right.
And they also usually need to come prepared. They need to get their documents in order. They need to understand if they're determining which holidays are with which parent, they want to have worked that out before we can write that stipulation.
Right. And then what happens if they get that stipulation and then both parties want to change it? Do they come back to you? Do they go back to the judge? Like, how does that work?
If it's a simple change, it's easiest just to have the judge do it. They can quickly get it done. But we actually encourage them to make it a living document so that they know as their needs change, rather than fight it out if something goes wrong, rework the agreement and then get it set as part of their decree.
So let's talk about the training side of that mediation. So when I think about family mediation, one of the assumptions I make is that you'd have to become very familiar with that area. Is that a large component of the training, or is it mostly about managing emotions, or is it kind of everything?
If you were to take the family mediation training right now, there are only going to be certain areas that are unique. the idea that you're dealing with the relationship component is where you want to start becoming really cognizant of the needs. Because, again, court, sit down, so how do we get here, what's going on? But this one, we're asking what their long-term goals are in a way. So they don't even know yet. They may be in the throes of those things. So being willing to walk that path is one of the things that you want to learn while you're in that family mediation training. You don't necessarily have to know a whole bunch of specific laws.
Okay.
Because whatever the dispute is, you're going to take time until it becomes clear for both parties. They don't even necessarily know about what causes that dispute.
Right.
It's whether you can be a good mediator and walk that with them.
Okay, and then how often, like percentage-wise, when you're doing a family case, how often is an attorney present?
If you're at the court, it's probably close to half.
Okay.
They don't necessarily need to even be in the room, but if they're present because they're with their party, the interesting thing is I'll usually just ask the attorneys if we can meet with them alone, and I would say 90% of the time they're okay. They'll consult with them. But the attorneys are also actually sometimes helpful, and they'll give us an idea of what they see are the main sticking points. So, yeah, I've only had to do a full mediation with attorneys present twice.
Really?
Yeah.
I thought it'd be much higher. Is that because your style is to kick them out, or is that because they just generally...
I ask them.
Yeah.
I don't kick very hard.
You don't kick hard, but if you can nudge them out?
Yeah, they've always worked pretty well.
Okay.
Yeah.
So they obviously can leave and consult an attorney if they need to
Of course,
during
we
that
recommend
process,
it.
because that's
Sure. Yeah, before they're agreeing to anything, we want them, because the attorney of record has to sign any stipulation anyway. So the attorney would roll it back pretty quickly if we.
So it's like in everybody's best interest to have that attorney be at
Totally
least eyes on the
aware.
document
Absolutely.
and giving the endorsement. Okay,
Yeah.
interesting. So another thing I know about you is that you're bilingual. And so I would ask you, do you do mediations in, it's Spanish, right?
Correct.
Okay, do you know other languages besides Spanish? I've never asked you that.
If I do, I'd just use enough bad words or something. Something I shouldn't do in a mediation anyway. So yeah.
So do you mediate in Spanish ever? I have done it obviously with translators, which I know you've done. Do you mediate in Spanish ever? And if so, when is that suitable?
Yeah, I do. Specifically if both parties speak Spanish. It's kind of inappropriate if only one party speaks Spanish and the other is English, because now you become an interpreter. And automatically, any bias that I have, not intentional, of course, but the way I think of words and then represent them now becomes part of our process. And I'm trying to be as, a window to let them see through, rather than like the smudges on the window that makes it hard for them to agree. So yeah, unless both parties speak Spanish, I would not mediate. I would ask for an interpreter.
Yeah, and I've used interpreters. I know you have. That makes a lot of sense to understand your role in that moment. To say my role is not to do the interpretation, it's to do the mediation. And so to the extent, or at least what I hear you saying is, to the extent that I'm able to stay in that mediator role and speak in Spanish, that's fine.
Right.
Because they
For
have the
both
capacity.
parties.
Yeah.
For both parties.
And they can hear each other, so then you're not doing that interpretation.
That's right.
But that interpreter can play a role. And just a side note for me is, I've had a couple of cases where I think the interpreter maybe is a little fishy.
I know I've seen cases where we had an interpreter, even in Spanish, and I'm hearing them say that that's not the words I would use to relate that phrase right there.
So it's like this, it's a challenge of maintaining that neutrality while still having an interpreter.
It is.
And so that, I have one interpreter who's my favorite, that I probably every few times get her in Spanish. And what I love is she's invisible. So I always feel like I'm hearing that person speak when she does the translation. And I said that to her one time. I said, gosh, you're my favorite because I always feel like I'm really working with the parties. And she said, isn't that my job?
And that truly is.
And I said, well, yeah. And she said, well, then I should be good at that. And I said, yes, but I just want to let you know you actually are.
Right.
Because I feel like I can really mediate the same as I would in English.
Right.
So, and I'm not bilingual, so.
And that's also why it's a little scary if the parties bring in their own interpreter, because they may kind of put a spin on things, and the court will usually provide one that's a certified interpreter. So that's
Right.
kind of an important part.
Unless it's an unusual,
Unusual, right.
or well, not unusual language. That's a terrible way to say it.
But
Less common.
less common,
Less
correct.
common.
Right.
So I had one in Czechoslovakian.
Wow.
And that was less common.
Very less common.
Yeah. So anyway, so you train mediators. Tell us about that, and tell us what you believe is the hardest area for a new mediator to learn.
I love training new mediators. One of the things that I love about it is it never fails. After about 2 or 3 days, we do a 40-hour training, and after about 2 or 3 days, the mediator realizes how biased they are. And that's actually a beautiful thing, because they're able to start noticing their own bias, and that affects them in good ways for the rest of their lives. Not only in those mediations, but how they relate to other people, how they see themselves in the world. So, and I've had mediators or new mediators say, it's almost like going through therapy. You're learning so much about yourself, and you're understanding how to communicate differently. So it's a great process.
Right.
As far as, what was the second part of your question?
What's the hardest area?
The hardest area.
So I don't know if that's the hardest area, maybe.
No, that's actually the fun part. The hard area is that as the new mediators come through, they're so wanting to be these great mediators and fix. They want to fix.
Yeah.
So they consistently want to get to what they think the problem is and then help them fix it.
Right.
And that's usually when you start missing all the important things.
Missing the whole mediation, perhaps.
In a way, yeah.
Yeah.
So my goal for them is to learn to trust our process.
Yeah.
Always back up. Do not become
Right.
part of the reason this isn't going well, but
Yeah.
trust that step by step they're going to get to their own resolution.
Yeah, that's interesting. So that's even on issue identification, right?
Absolutely.
That can start very,
Frequently.
very early. Can
Frequently.
that mediator get into that trap? So that's
they,
interesting.
And they forget to do the things we tell them are number one, like restating and those very simple parts of the process that help things turn those wheels forward. And it's because they're thinking of how they're going to help fix it, do the process.
Right. I have sometimes I'll be in mediations and a disputant will say, "Don't you think this is the problem?" And I'll have to stop right there, like any inclination to say whether I think that or not, and say it depends whether you think it is.
Right.
Right. Like in other words, don't hand me the ball. I'm going to hand it right back to you. And I would say that's pretty typical of me as a mediator is to hand it right back. Whatever you give me, I give you back because I don't want to be a player in the game.
That's right.
Right. I'm trying to help you play the game.
That's right.
And so that's kind of an interesting thing. What advice would you give a new mediator? I know you give advice to mediators that you train. So what for this class, what would you say are some things to consider?
Number one, do trust the process. And number two, always try to think of yourself as one of those parties. How would you want to be treated? The golden rule type thing, right? Because as a mediator, at times you may feel like a little nudge one way or the other is helping them. But we never know their story.
Right.
We never really know all the things that are behind that. So it seems to us, in our limited view of their dispute, this is good for them. what we really want to do is make sure they have learned why it's good for them and why they're agreeing. So yeah, being patient with that process and just treat them like you want to be treated. Be patient with them, that type of thing. That's how I want to be treated.
Yeah, I love the idea that you don't know the story.
You never know the story.
And that, I think, it comes with experience in mediating a lot of cases where you're really surprised by a new piece of information that changes everything.
Right. And that's,
you have roommates like dispute, or you have business partners and then you find out that they never really were business partners, or you have, it could be anything.
Right.
I've had a case.
There's a relationship in their past somewhere that, yeah.
Yeah, I had a case a while back where they failed to communicate, and one party just said, "I don't get it. I don't get it. I don't get it." And I was thinking in my mind, like, I don't get it, but then I thought, don't say that because you're siding, right? Just let them do their process. And the other disputant revealed a very compelling explanation about an illness in her family that was prohibiting her ability to communicate.
Wow.
And the whole thing changed.
Yeah.
They said, gosh, I can be way more accommodating.
Yeah.
I totally understand. I'm sorry. Very different change, and never saw that. I never saw that coming.
Right.
But I was so happy I didn't get in the way.
Right.
So, because she looked at me and said, you need to tell her to talk to me. You need to tell her to answer my emails. And I said, why don't you tell her about that?
Right.
And when they went back and forth, it was like, oh my gosh, that's why this has all not been dealt with. And then they became very, very agreeable, and it was, 15 minutes to the agreement, I think.
It's really true. When it's almost like sometimes they may hear it for the first time. They've been saying certain things, especially in family cases. They've been saying it to each other for so long. And now a mediator does a restate, right? We hear the information and it says, it sounds like this is what's been happening. And the other person says, is that what you meant all that time?
Yeah.
And it changes everything.
Right.
A chance for a little compassion or empathy for the other side, all of a sudden they start working together in ways that they didn't realize they would even want to.
Right.
Yeah.
And I've had that also with emotions. I would kind of throw that topic into that conversation to say, I've had people who are maybe settling debt or car accident or whatever, and not realizing the other side's emotional reaction to that.
Right.
And then all of a sudden they're like, wow, I had no idea you were this upset about it. And sometimes as a mediator, and a lot of you probably have this too with the ones that you train, where a lot of my mediators say, I kind of don't want emotion because it's too scary to deal with, right?
Really
I don't want to have it,
uncomfortable.
I don't want to have people get mad, and I don't want to have people get sad, which are the two big ones that we get, right? And not that you get everything, but
sure.
Or I'll have certain mediators that say, it's fine as long as nobody cries. Okay. And I'll say, well, except for that we're emotional people, so that's not going to work.
And that's where they may be.
Right. And so one of the things that I try to think about as a mediator is this notion of holding space for emotion that needs to be considered. And I'm not engineering that or saying, I can't facilitate that, I can't trigger it, I'm not doing any of that. But if I see it and say, wow, this will promote a great amount of empathy or understanding like you're talking about, I might hold space for it. In other words, allow it to happen rather than rushing in and saying, anyway, we need a break,
or
we have to stop, or we have to stop this line of questioning.
Right.
And so one of the advice areas that I give new mediators is sometimes when you're uncomfortable is when you need to stay in that space.
Yes. Sometimes silence, just allowing things to settle with the group is exactly what's needed.
So I would think in family this would come up quite a bit.
Yes.
Just all the range of emotion.
Yes.
Right? Because you have so many levels of potential disappointment and hurt and regret and everything, So my suspicion would be that they haven't held space as much for the other emotional reaction.
Yeah, usually they're so quick to react towards each other. A very good friend of mine, mediator, she's quick, and when she's doing her training, to add that in a mediation she can do exactly that, hold space, be present, and good restating listening skills. But with her husband of 36 years, she knows what he's going to say, and she's already over it. I mean, and this is a mediator, so we're all human. We all have that, and so that neutral is the one that is able to help something like that happen.
So I'll be married 29 years coming up here, but I'm not 36, so I don't have that kind of experience.
Right.
But I would say I do understand the dilemma.
Yes.
For sure.
Yeah.
Yeah, that's funny. Well, I think that when we take on a role, I mean, as you're kind of suggesting, it assumes that we take on a number of behaviors with that role, right? Or suggests that we do that, and so that I can see the dilemma for that person to transfer and say, now I'm wife, forget it. I'm going to tell you what I think, right?
Right.
Yeah.
And you really can't. I mean, it's almost impossible to mediate your own dispute with someone. You just have to be a good partner or party in your own dispute.
Right.
Because you're in it.
Right.
So,
right.
yeah.
Yeah. Okay. So last question for you. What are your thoughts about the future of mediation in California, in Southern California? Where do you think we're going with this? I hear all the time it's, growing and it's changing ADR and all these different things. Thoughts about that?
I do think it's growing. I think what we're seeing, especially because there's things like restorative justice now taking root, which is a form of mediation, but it's more like an entire process rather than just resolving one dispute. People are starting to look at how to handle conflict differently. And mediation is not only sought out because it can be less expensive if it is a divorce, but more importantly, if it's done well, they do have a better outcome.
Yeah.
It's better for the people that are part of it. So you asked about whether people can have a career. Yeah, you can be a highly successful divorce mediator just specializing in that. I mean, there's plenty of people getting divorced.
Right.
So
Yeah.
yeah, I feel like people are trusting it more and more, and we need quality mediators,
Right.
not just someone that says, I can do that.
Right, and that's an important distinction that I think you and I work on every day
Every day.
as we train people. So,
Yeah.
all right, very good. Well, I'm going to stop this section. We have another section coming that I'm going to invite you to be a process of,
Okay.
or part of that process. But thank you for the interview part and for
welcome.
coming in. Love to hear about your practitioner role there. So that's an important thing to have on the show to consider and to kind of hear what the real world.
Real world.
That's your world, is the real world, by the way.
Real world mediator OC.
Mediating in the OC versus everywhere else is a great
Exactly.
question too.
It's
So,
true.
all right, very good. So for this last section, I have a new part of the show that I'm going to introduce today, which is called Ask a Mediator. And what this is a section where I'm going to take questions that have either been posted on the discussion board, brought up in email, or just alluded to in any kind of way where we can identify different questions that have been asked that maybe don't hang together but are just different questions and have a chance to answer them. So I'm going to invite you, Wesley, to be a part of that process, and we'll try to answer some of these questions, I think both of us, as we would answer them. So
Let's do it.
let's do it. Okay, so the new part of the show is to take questions that have come up in the course. So the first question I have is, what do you do when disputants don't have effective communication skills?
That's most of the time.
Okay, all right.
So a lot of times it's helping. The first thing I want to do is help them understand what the process really looks like, how it works, because they're not going to be able to communicate on their own. Having a structure helps them. So that, and then I do a lot of restating where we're summing up what they're saying, giving it back to them. Because the other person, like I said, might be hearing it for the first time.
Right. Let's see. So how would I answer that? I would say yes, most of the time they don't have effective communication skills. I guess for me, I think of it a little bit differently than that. I think that, but I also think sometimes there might be even capacity issues of whether they can participate in the process at all. So I've had some individuals with some mental challenges and maybe not able to even represent themselves, which is a dilemma.
Yeah.
And so I'm kind of thinking about it, I guess, both ways to say there are people who simply just have less skill, and then there's people that actually, maybe can't represent themselves. But the question I'm asking is, can this be a fair process for that person is something I always think about as a mediator, right? So if somebody mentally can't track with what we're doing or doesn't have the ability, that I wonder about mediation as a process for them if they can't be equally helped, right?
Yes. Yeah.
So
they have to be able to participate fully on their own.
Right.
Yeah. To be voluntary, they have to actually be completely in it.
Right.
If you're limited how you're able to participate, that's not really you saying yes. That's the part of you that was still there.
I had recently, I was in a civil case, and the disputant got very, very upset with me.
Okay.
And started pointing her fingers at me and pounding the table and yelling at me. And I know, it just happens, right, in doing business. And so she was very angry about how it was going. She said she was no longer going to win, which wasn't what we were doing anyway. I know you appreciate that, right? And so one of the things that was interesting is after she left, there were a couple of observers in the room who were training for mediation. And they said, wow, we can't believe how poor the communication skills are here. And I said, are we surprised?
Right.
I mean, we can't be totally surprised that you needed to have a third-party stranger help you.
They're in conflict.
Right? You couldn't work it out. And so now we're going to invite someone who you never met before.
Right.
Who at least has training, but will be helping you. And that's kind of, kind of an interesting thing to think about.
Yeah, a lot of times those people have had conversations with the other party, but only in their mind.
Right.
They've worked it all, why this won't work and everything in their mind. They've never actually taken the time to try a meaningful conversation.
Right.
So we may be that first time it's happened.
Yeah, and I would say about 50% of the time in small claims, people haven't, is that what you'd say? About they haven't communicated? About half
or
the time,
really
which is
poorly,
startlingly high to me.
Yeah.
Or poorly, poorly executed.
A lot of people are afraid of how they'll actually act if they were to confront, or even if it's in a useful way, how they're going to be with that person. They'll lose their temper, so they've avoided, and now they're in court.
Right, and I think about that all the time too, because I think we're in an era of texting, emailing, like it couldn't be easier, really.
Right.
In terms of portability, right,
of
the
message.
message.
It happen, there's a way to do it now. Yeah.
Right, and then, so instead of that, it's like what you said, that avoidance bought you a formal, structured conversation with that person.
Yes.
So avoiding really didn't work out as a strategy, which is kind of interesting. If they did the math, they would, but they don't understand the math, so.
Right.
Yeah, okay, next question. What do you do when parties are crafting a bad decision?
You want to go first on that one?
Well, the comment I would make first is there are no bad decisions if I am the one judging that. And so that's a tricky one that I think is very frustrating for mediators, is that some parties will agree to a resolution or settlement that they like, that I might not like. And so part of the question becomes who's judging it as bad. So that's, I guess, where I'd start with it. What would you add?
I fully agree. I've actually mediated cases that I watched what was happening and realized this really isn't, in my opinion, fair.
Yeah.
But it's where they are. That's the challenging part. So as a mediator, my best job is just to check in and maybe caucus even to see that they're actually comfortable.
Right.
Even if it's an uncomfortable situation. They're cognizant and aware. And it was their dispute to begin with, and it'll be their agreement.
Right, so they own all parts of that process.
Yeah.
You know, that's interesting to think about a caucus there, because I was thinking about when you were talking about the testing the settlement, which we talk about in the later stages of mediation, saying, what will happen if this, what happens if you guys agreed to pay each other on the 4th of every month? What do you do about 4th of July?
Right.
Or
reality check.
Do the reality testing. And so we do all these different things in mediation to do that. And so I was thinking that actually is a great one to think about, using a caucus format to say, hey, so how are you feeling about this?
Right.
You know, what are your
Well-
concerns? Kind of checking it for its durability.
And it's more important in family situations because if the emotions are high and they're now started to what we would call retreat, they're just giving, anything that the other party's expecting.
Okay, yeah.
Then it's okay for a mediator to make sure we're keeping it as balanced as we can to say, hey, we're going to take a break, you know, and then we talk to each party separately. And they still may go there, but you've done your due diligence by making sure they're aware as much as you can of what's happening.
I'm thinking about one case I had one time. It was in civil harassment. It was a neighbor-neighbor dispute. And they had been feuding for about 4 years. Many calls to the police, you know, it's something pretty typical that we see in that court. I know you've been in that court. One of their solutions they put on the table was to build a fence together for 3 weeks. And they had engaged in very negative interactions leading up to that.
Yeah.
And so I said, so given the fact that you, for the last 40 minutes, have described the negative interactions
awful.
you've had, and I mean negative is like very, very lovely way to say it. How do you feel about working face to face on a project together on your joint property lines? And one of them said, oh my gosh, that's a terrible idea. But I wasn't trying to engineer that. I just said, you know, how do you, like, you're talking about a very big change in communication. What do you think about that?
Right.
Because I thought to myself, oh no, like someone might get hurt here. You know,
Start
like
throwing
I don't know.
hammers at each other.
I
Have
don't
a
know.
nail gun.
Yeah. So anyway, and that's where you have to be careful. I think there's a line to think about as a mediator to
Yeah.
say, wow, because I thought immediately that's a bad decision, you know, but
Right.
it wasn't, you know, you just have
So
to
you
check
reality
it.
check
and
it. Absolutely.
Yeah, and you put it in front of them and say, given the context
Yeah.
that you provided and a 4-year history
Right.
of this, is this something you think?
How does that look? That's what
How
we
does
like
that
to
look?
say.
You know, and also, do you think there might be bumps, and what might those be if you could anticipate them? And then the one disputant said, "Wait, we can't do that." I was like, "Oh, okay. What do you want to do then?" Right? Okay. So next question. Let's see here. Oh, how do you keep it neutral?
Well, I can keep myself neutral.
Okay.
The mediation, I try to keep as much as I can that the amount of time I'm giving both parties is equal, that the attention I'm paying to both of them, when I restate things here, it sounds like I'm being fair and the same with them. So the way I'm participating with them, I'm going to make sure is neutral. And a balance of power, if someone's really trying to be overwhelming,
Which definitely happens.
definitely happens. You can use things like taking a break and something to let it cool or calm down, or try to bring both people back in a different way. But in a way, it's kind of like we never really can keep it truly neutral. What we can try to do is keep it moving, in my opinion, because once they start moving in the same direction towards a resolution, that is the neutralizer. That's when they actually start owning
Right.
and wanting to go ahead.
Right.
Up until then, if their positions are just super
Yeah.
hard, you can't change their position. You can
Right.
open up to interests.
So something you just said reminded me of another concept that's highly related to this, which is equality. Because you were kind of putting them both together, because I think they go together in mediation. And one of the concepts that I teach my students is it's not equality, it's the perception of equality.
Right.
And that sounds so fishy and terrible. And so immediately I'll get a hand up in the air saying, that's a terrible idea. You need to treat everyone equally. And what I say as a mediator is it's impossible to do that. So I can't give you the exact number of seconds to speak and then the other one the exact number of seconds.
Right.
What I can do is give you the perception that you have an equal voice.
Right.
And the option to have that voice. So one of the dilemmas that happens often for me is, and you've seen this very often in mediations too, where you have one person who talks a lot
Yes.
and one who doesn't talk a lot,
Right.
And so one of the strategies that I like to talk about there is to say, I need for that introverted person or less extroverted person to believe they have as much of a voice as they would like to have.
As they want to have. That's right.
Right? So what I might do, to give that perception of equality, because that other person's going to fill the space. If I, so I might do more closed questioning on that side, just to keep the story smaller.
In that container.
Right, which never happens.
No.
And then, well, not never, but
Right.
And then on the other side, asking more open questions or saying, is there anything else you'd like to
draw
add?
out. That's
Anything
right.
else you want to tell us? Anything else that you think is important to the case?
Right.
And I feel like that is a way to, you can't make it equal. And even the less extroverted person doesn't even want to be
Right.
equal. They're like, I'm good. I summarized it. I've said what I would like to say.
Right.
And so then I try to, as a mediator, give a strategy there, to kind of facilitate that. But
And caucus can work in that too.
for sure.
Yeah,
Yeah, that's a good comment.
Even for the party that's very verbose, if it's 5 minutes with the verbose and 5 minutes with the other, that helps them say, "Oh, I'm being treated the same."
Right.
So they may mitigate or start to shift how they're looking at things and start saying, "Oh, I guess I'm just part of this process.
Right.
I'm not the owner of this process."
Right.
So, yeah.
I had a funny thing happen, I think a month ago or so. I was in civil harassment and where there's so much storytelling. And I said to the disputant, I just need you to give me 4 or 5 sentences that summarize why we're here today. Just an overview so we can get kind of a general view. And she said it all started on a Thursday. And I was like, oh no, it all started on, and it was just like download of information. And I was like, oh no, like it all started on a Thursday. The level of detail coming, I'm in
She'd
deep
been
trouble.
rehearsing for months.
Yeah, truly. Okay, next question. Okay, so what's your advice in handling emotions in mediation? You heard I talked a little bit about my perspective. What about yours?
The way I typically will handle emotions are, number one, is this something that registers as so important that to not have space to do that, they won't feel like they're fully in this. They need that permission, even if it's difficult for the other party to hear. After that, then there are times people can use emotion to manipulate, to try to give the impression that they've really been worked over and so forth. And so if it's disingenuous, we don't necessarily need to spend a lot of time trying to console or something like that. What we want to do is make sure that they're allowed an equal voice, like we talked about. But I'm personally okay if they're expressing emotion. I want to make sure that it's still a communication rather than just an outburst.
So how do you know the difference between the disingenuous emotion and the visceral one? Like,
well, and this is something I think
intuition?
It's almost, and I guess in a way I'm kind of being a judge of it, but what I'm trying to do is make sure that the process is being given its full breadth, especially in a family case, because that may be why they take the next step.
Okay.
They're realizing this is painful and I want to move forward. I don't know what it's going to be.
Interesting.
But I'm personally okay. As far as whether it's genuine or disingenuous.
Yeah.
I think a lot of it times it's in their energy. It's kind of like their body tells you whether it's like they're putting something into it. You can see the reaction from the other party.
Yeah, true.
You start getting a sense of it. And so that's where a good reflection, you can give it back to them.
Yeah.
And it kind of catches them and they almost hear what they're saying and doing a little. So, every case is its own
every
thing.
case is different because every human's different.
Yeah.
How
about you?
One part that is occurring to me, well, just a related topic, is when you paraphrase or reflect back the emotions you
Right.
believe you're seeing,
Right.
and how terribly difficult that is on the mediator's part. So if they're crying and you say, I see you're a little upset right now,
Right.
your underestimation of that is going to probably get a very bad
Agreed.
reaction.
Agreed,
Or if you
right.
say, I see you're hysterical now.
Right.
Right? So the terminology used on the part of the mediator to
Yeah,
reflect back
you-
those
you need
emotions. I mean, I find sometimes I won't even say what I saw. I'll say, how do you react to this?
Right.
To my other disputant,
So you're allowing
only
it to
because
move
I'm
across.
I'm just not even sure if there's an accurate way to say. Obviously, this person's devastated. Do I use the word devastated? You know,
I don't use that word.
right? But I mean, it's
Right.
difficult. It's a difficult thing.
Yeah, a generic for myself would be something like, I see this is very upsetting for you.
Mm-hmm. Upsetting's the bucket for a bunch of things. That's probably good. That's probably a good word.
And then if something more comes out at that time, then you can reflect on the things that caused it,
Mm-hmm.
and that can start those wheels turning for both.
Right.
Now they're connecting to what the root of that emotion is. You're not meant to address the emotion directly.
Right.
You're meant to help them connect with the root enough to make the decision about what they want to do now, in my opinion.
Yeah, that's interesting. And so then that goes back again to the role clarification, saying
Yeah.
I'm not here to counsel you
Right.
or to be your psychologist and get your shame triggers taken
Right.
care of today or whatever. You know, I have
Brene
to.
Brown.
Yeah. Hey, I love Brene Brown.
I love Brene. She's
So,
awesome.
you know,
She's great.
We can talk about her today.
Yeah.
So anyway, yeah, that's interesting. All right. Well, very good. Well, these are our questions for today. So I think we covered it. And
Good questions.
very much appreciate you being here today. Thank you so much for coming on.
Thank you for having me.
My pleasure. So we are signing off for this show, and I will see you next time.